In this video, we're discussing some of the things people constantly get wrong about gun laws with top criminal defense attorney Tom Grieve. But before we get into that, we have a gun giveaway going on right now. You can enter for free, but it ends really soon. Just click the link in the description down below to reveal which brand new gun you could win. Tom, people think they know the gun laws, and that's what gets them in trouble. And there's what, like 20,000 gun laws or more across the country, and we constantly hear some crazy stuff. Our own president at one point said you should just blindly fire 2 shots into the air to scare bad people away, and we all know that's illegal. So let's bring that one up first. Warning shots. People think you should fire a warning shot, and that's going to make the bad guy run away. What's it really going to do?
It's really going to get you criminally charged in cases where I have seen warning shots. That's what it will do. I'm aware of the fact that our president made a comment to this effect. I'm aware of the fact that the prosecutor in the Rittenhouse trial said basically, well, not basically, he said he should have done warning shots. I'm aware of those things. Here's what actually happens. You are going to be criminally charged, and they will try to put you in jail.
Yeah.
Period.
This is reckless endangerment at the very least, reckless discharge of a firearm within city limits or wherever.
Right.
This is a crime to shoot a gun at nothing.
So here's what you're looking at. So I have seen recklessly endangering safety, which depending upon how it goes, can either be run as a felony or as a misdemeanor. You could be looking at possibly decades in prison to maybe only months in jail or something like that. I've seen disorderly conduct while armed. I've seen those. And then you get to see some more interesting ones, which is really a lot more context driven. So many states and jurisdictions will have laws involving you cannot discharge a firearm within X feet of a school, within X feet of a dwelling or a home. There's weird hunting laws that can come into place that maybe don't appear on the criminal code, but that doesn't mean that it's not in the prosecutor's tool bag to come after you with. So there's all sorts of different things that are out there that I have seen cops and prosecutors, more so prosecutors, go after people on. And that's just the way it is. I'm not saying that's the way that ought to be. That's the way that it is.
Yeah, if you're going to pull out your gun and use it to stop a threat, stop the imminent threat. No, the bullet has to come down somewhere, and where it comes down, that's where we get this endangering safety, that you don't know where it's going to go. I shot over his head. Well, what was over there? And what was over there for the next mile that,
right.
that your gun, your round could come down, your bullet could come down and impact. So, all right. No warning shots. We've been saying that for years. We've been saying warning shots for years. Here's the next one. I can shoot anybody in my house.
Yeah, don't.
Yeah.
Free legal advice.
Yeah.
Don't.
Yeah.
All right. So generally speaking, okay, let's quickly recap self-defense law. Before you can use deadly force, you have to show that you are in reasonable fear of imminent death or great bodily harm. Different states will play at those words. Maybe instead of imminent, it's immediate or whatever the case may be. Other states may also have duty to retreat laws, sometimes only outside the home, sometimes who the heck knows where. Other states will have stand your ground, other states will have Castle Doctrine, and so forth. And particularly when we start getting to Castle Doctrine, that's where we kind of get a lot of these questions popping up, right? Mm-hmm. Of, hey, I invited over my sister and her new boyfriend. Turns out he's kind of a crazy lunatic when he starts to drink, and by the halftime show, he was just kind of going off, right? Yeah. Generally, in order to trigger Castle Doctrine laws, they cannot have been invited into your home, even though they may lose that invitation if they get drunk, rowdy, dangerous, whatever the case may be, maybe even homicidal. But that will be probably just kind of a generic vanilla self-defense law that will not be Castle Doctrine. Generally speaking, in order to trigger Castle Doctrine, someone will have had to have broken into your home, your dwelling, your car, your business, wherever it is that we're talking about Castle Doctrine applying.
While you're in it.
While you're in it.
Yeah.
Right. That's the very operative second part of that people frequently get wrong. They'll see someone messing with their empty car in their driveway. They're leaning out the second floor of their home, their apartment, whatever the case may be, and they think, oh, I know my state is Castle Doctrine. I'm just going to whip out my 12 gauge and throw down some justice.
Yeah.
Not the way that works. That's defensive property, not Castle Doctrine at that point. Yep. Okay. So the bottom line again is Castle Doctrine, this only applies if you're in the location, generally speaking, and they have to have broken into. Now, broken into It could involve a crowbar, could involve a screwdriver. It may just involve them pushing their way through an open window, an open door. Again, check your local listings to see how that all applies.
Yeah, and there's still cases out there. Recently, one in Ohio, which is a strong Castle Doctrine state, where the people were in the house, but they were running away, and the homeowner shot them as they ran away, and he was still charged with attempted murder because they were no longer what the prosecutor considered a threat, even though they had broken into the house. But when he made himself known, they were like, "Oh, sorry, see ya, we're out," and they took off running away, and he shot them as they ran away. So you talked about this all the time, the presumption, and a presumption is rebuttable. People have to understand it's just not blanket immunity that you get to shoot anybody who's in your house.
Yeah, this isn't a Hollywood movie. This is not a license to kill. Castle Doctrine, materially speaking, creates a presumption under the law that if somebody's broken into your home, you don't have to wait for them to plunge a knife into your chest. Yeah. You can presume, and there is a presumption that's working for you, that they are a deadly threat, and you can now take action. But of course, as you just said, anytime there's that P word presumption, there's an R word rebuttable. And the prosecutor can and will introduce evidence to show that, you know what, they were running out the front door and you shot them 3 times to the back and once to the back of the head. They were definitely no longer a threat at that point, and presumption probably under those fact patterns, gone.
Yeah, on the law enforcement side, we call that the totality of the circumstance. We got to consider all of that stuff, and certainly the prosecutor is going to do that. The investigators are going to do that. So that leads us back to the next one when you said 3 shots in the back and 1 in the head. If you shoot somebody, you better kill them. I've heard that so many times, and I'm like, wait, stop. We're not trying to kill anyone. We're trying to stop the threat. So this discussion point of if you shoot somebody, you better kill them, how can we get that out of the lexicon? How can we convince people that that's not what we're after?
If somebody's no longer a clear, deadly threat against you, again, depending upon your state's formulation of laws, if somebody's no longer a deadly threat against you, you are no longer privileged to use deadly force against them. Okay. So if they're running away, they've dropped their weapon, maybe even they've surrendered, which of course is a super, super dangerous scenario to be in. Right?
Yeah, that's the worst time is when they think they've given up.
Better that they run away, for sure. But if they're no longer a deadly threat, Castle Doctrine, all those things will likely melt away, and you're going to be facing homicide charges if you pull the trigger.
Yeah, as difficult as it is, there is this sequence of shoot and assess. And shoot again if you need to, and assess. And sometimes you got to do that really, really quickly under very intense stress. But if you don't, like you said, you could end up facing homicide charges for something like this.
And we saw, you know, in the Rittenhouse trial, just to keep going back to that, of the very first shooting that took place that evening in question, Mr. Rosenbaum, where he was shot a number of times, I think 3 or 4 times off the top of my head. And this all happened in, I think they testified, I mean, it was well under a second. I forget if it was 0.75 or 0.85, but it was well underneath a second. It's really difficult to shoot and assess in that scenario, and it's also very difficult for the prosecutor or for the defense to try to pull that apart. So I think one of the lessons that I took out of that, or rather was reinforced by that fact, was there's a value of carrying weapons that it's going to be a little bit more emphatic and a little bit more immediate if we made an impact. And you and I have talked about this before. And I don't think there's any disagreement necessarily, although maybe there will be, of, you know, look, AR-15s, fantastic weapons. Love AR-15s, pro AR-15s. I think both of us are, right? However, all the reports I've heard from veterans who have done deployments overseas and everything else, you're talking about 3 to 4 shots to neutralize a threat. There was a word for that the prosecutor used, homicide. Yeah. Right? And I won't go through it right now, but I would say that any self-defense weapon where quite foreseeably, even at close range, we're going to have to use 3 to 4 shots to neutralize a threat should not, for me personally, is going to be my number one as a citizen trying to defend themselves against criminals. That may not be my number one choice.
Yeah, and if you're opening the caliber debate, you know, and all of the 45 ACP folks out there who are, you know, old, fat, and slow, and then that could be me. Understand that most handgun cartridges are not going to give you that lightning bolt stop, that immediate cessation of hostile activity. So that the shoot and assess part comes in, and it is difficult, and we understand that. And it takes time to decide what you're going to do, but then it also takes time to decide to stop what you're going to do. So when we're talking about the span of 3/4 of a second, that's some pretty quick thinking to get your finger to stop pulling the trigger that the threat is now down.
Right.
But no, don't just keep shooting till they're dead. Absolutely not.
Right.
Shoot until you stop the threat, and when you reasonably believe the threat is stopped, stop shooting and only start shooting again if you know that there's another threat.
And there's a difference between shooting once or twice and reassessing versus shooting 3 or 4 times. And that's not my point. That's effectively the argument that a prosecutor in a United States courtroom tried to make to put someone on a life sentence behind bars.
Yeah.
So don't shoot the messenger here. What I'm trying to do, and what we're always trying to do, is we're not out here necessarily stumping for X or Y position. At least that's not my position. My position is, here's what's going on.
Yeah.
Here's what's going on in courtrooms. Here's what's
going
going on
to
in
happen
laws.
to you.
Right.
Yeah.
Here's what's going to happen to you, and you need to know about it. You owe it not only to yourself, but you owe it to your family, you owe it to your friends, you owe it to everyone to understand here's what's going to happen. And that way you can take those data points, you can factor it in as part of your training, your education, and make hopefully better decisions.
And now we can wrap this up, because I know we might be getting kind of long for some folks, but we'll wrap this up. This will be an easy one. So, and it is, well, if somebody comes to your house and you shoot them, drag them inside and make it look like they kicked in the door or something like that. How do we handle that?
Don't.
Very good. Absolutely. Don't tamper with evidence, people. That's what all of this is. And the investigation is going to go on much longer than your 4-hour concealed carry class and all of that other stuff. So I hate it when I hear it. It just grates on me when it's like, yeah, drag him inside. No, that's really going to get you in trouble.
Big trouble.
Yeah, absolutely. Well, thank you again, as always, for your insight, for your knowledge about all this stuff, and your willingness to come help us out, Tom. I truly appreciate it. Folks, thank you for watching all the way to the end of the video. And I will remind you once again, we have that gun giveaway going on. It ends really soon. So click the link below and reveal which brand new gun you could win. I'm Kevin Michalowski, Director of Content for the U.S. Concealed Carry Association. If you like videos like this, please share this video everywhere. Click the like button. Click the notification bell. We'll notify you every time we come out with something new. Stay safe.